being joined on the phone line by Mr. William Nyarko. Mr. William Nyarko is Executive Director for the Africa Center for International Law and Accountability. He's actually been following this dispute since it started, and he'll give us some insights as to exactly, what has been going on with regard to this particular case and the ruling. Mr. Nyarko, good morning. Welcome to the Ultimate Breakfast Show.
Good morning, and thanks for having me.
Thank you very much for taking time to speak to us this morning here on the show. I'm pretty sure there are a lot of Ghanaians out there who are a bit confused about this particular law, and when you read the ruling, some longitudes and latitudes being given, some big terms being used like equidistant and all of that. But I want you to break it down for our listeners so that we can get a better understanding of what all of this is about. First of all, with this ITLOS, the International Tribunal of the Law and the Sea, exactly what are they and what are they really supposed to do?
So that's a great question. So, under international law, countries will sign up to a treaty. So let's say in a contract between you and I, there's paper that you sign and then I sign, and then it will bind both of us, right? So under international law, because the law will be between states, so Ghana and Ivory Coast and all nations that sign on to this, there has to be a uniform law. Instead of using, for example, in this case, Ghana law to address it or Ivorian law. So the law that allows the institution called the International Tribunal for the Law of the Sea to use this law to try and settle dispute. It's called the United Nations Convention on the Law of the Sea. Think about it in terms of Parliament passing a law which is assented and establishing the Ghana Supreme Court. So the law is called the United Nations Convention on the Law of the Sea. That gave rise to the building called the International Tribunal for the Law of the Sea. Under international law, a country is bound by the law if it has ratified it. So Ghana has ratified, Ivory Coast has also ratified. So on the basis of that, when a dispute arises, as in this case it did arise between Ivory Coast and Ghana, you look at the law that allows the settlement of the dispute. And the International Tribunal for the Law of the Sea is given the power, in law we say jurisdiction, to try to deal with certain disputes. And one of them is maritime boundary disputes. So, as you know, if this is the boundary on the sea, that goes out into the sea. So it has the jurisdiction, the power to address issues like this.
Okay. Who forms this law? Is it all countries under the UN who come to a certain consensus, or there are certain elements within the UN which actually sit down to form these laws?
It is all countries. Normally what happens is that an idea will be mooted by sometimes the think tank of the United Nations called the International Law Commission. They would say, what is it that needs to be done? And so they will put a draft together and they will circulate it around to all countries. So you will normally have what we call a diplomatic conference where all nations that are interested in it will participate. And this final one was done in Jamaica. So all countries that were interested in this treaty called the United Nations Convention on the Law of the Sea met and deliberated and decided that the final text of this law is the thing that they were interested in first signing and then secondly ratifying it. So if you take it like Parliament, see the way we make law in Parliament. A bill is muted and it goes round the discussions until it is passed. So this follows similar ways in which we make law under domestic law. So once it was finalized, it will be open for signature and ratification. And bear in mind that because there is no international parliament that makes law, and law is made by the various parliaments in their various countries, that's why under international law, you would have a signature. So let's say Ghana would appoint maybe sometimes the foreign minister or the attorney general to go and sign on behalf of Ghana. But that signature does not make that international law binding on Ghana until we have brought it to the people who actually make law, whom we have voted to make law, the members of parliament, until they have, reviewed it and they have done what we call ratified it, and then after ratification, it is deposited with the UN depository, and then it becomes binding on us. So in this case, it followed the same process. Ghana ratified it, Ivory Coast ratified it. So then we have a level playing ground to say that when there is being this dispute, we would use an international law, which we have all agreed to help us settle this case. Instead of, using Ghanaian law, there's a tendency that we can be biased against Ivory Coast if we use that. And Ivory Coast would not have agreed. In the same vein, instead of using Ivorian law, which we will not agree to. So this is an impartial way of having a dispute resolved under international law.
And essentially, every country in the world who is a member of the UN ascribes to this particular law and has ratified it.
The UN, law, it's different. The way it is that when you sign on to the UN, you are saying basically that you would want your issues with other countries to be dealt with peacefully. That's what they call the Pacific settlement of disputes. So that's a separate law. So it is like you have made one law establishing, let's say, parliament, and if there is another law, it is separate from the one that was established. So you have to sign on to every law that comes before we can say that it is binding on you. But also, under the United Nations, this is a point that you stress, because every state that is a member of the United Nations has ascribed to peaceful settlement of disputes. All of these other international treaties that are signed and ratified by states, they connect to the UN, the bigger UN mandate or agreement by states that they will settle matters, disputes peacefully when it comes. That's why, for example, it was very worrying to the United Nations and other members when, for example, U.S. President Donald Trump stood in the United Nations, which is supposed to be the body that deals with peaceful settlement of disputes, when President Trump, for example, threatened to eliminate or to get rid of, wipe off North Korea, so because it's an institution which deals with peaceful settlement, and issues of threats and all of that are not allowed.
Now let's go to the genesis of this problem. This dispute between Ghana and La Côte d'Ivoire. Did it start when Ghana discovered oil and that we could drill it in commercial quantities, and that Côte d'Ivoire also wanted a piece of the cake and so began this dispute with us?
It was within that context, and I think it goes back to 2006-07. And that was around the time that oil discovery, was announced, and ITLOS started some exploration, just testing to see if they existed in commercial quantities and all of that. And so around that time, Côte d'Ivoire and Ghana, there was a back and forth. As I understand from the literature, there had been about 14 meetings or so to try to resolve this, and all of it failed. And so at that point, the Republic of Ghana and the Attorney General, Mrs. Marietta Brew, I understand, advised the President, then President Mahama, about possibilities, and then it was decided that rather than go back and forth again, and within which I understand that Ivory Coast had been issuing threatening letters and actually also trying to hamper the operations in the disputed area. Therefore, Ghana decided in September of 2014 to file the case against Ivory Coast, asking the court, this was very important, asking the court to order to make a decision that it has not, violated Ivory Coast sovereignty by having drilling explorations in that area. And so, and as you know, when the decision was made, that was one of the unanimous decisions that the tribunal reached, that indeed Ghana had not violated the sovereignty of Ivory Coast in its drilling operations.
Before it got to that point where Ghana decided to go to court with this, somewhere in 2015, what efforts were made to settle this dispute between the two countries without it having to reach that point?
Yeah, I understand from the literature that there were lots of meetings and discussions between the two countries, which is one of the initial steps that you would want to take. Because as you know, Ivory Coast and Ghana have had long-standing relations. So all of those attempts were made, I understand, about 14 occasions to resolve this matter between the two countries, and it did not work.
And this was the only way that Ghana and Cote d'Ivoire could have this matter resolved, and so it had to go to the international court, the international tribunal.
Yes, you have to look at the history of of this dispute. If countries had tried on 14 occasions to resolve the dispute and they were not successful, this was the next step to give it to an independent body to try to resolve the dispute. Within the African system, people have asked, why is it that Africans cannot solve their problems and have to go to an international court, in this case the ITLOS, to resolve the dispute? You have to look at which institution in Africa has the mandate to resolve a dispute about maritime boundary delimitation. No institution, legal institution that both countries have signed on to in Africa could have addressed this issue in the manner that this has been addressed. And because both countries have ratified this law, this international law, it was all well and good that they went there. I know that the constitution, the composition of the tribunal has the judges and then what we call judge ad hoc. Judge ad hoc are typically, selected by, the various countries, for example. So Ghana selected a judge ad hoc called Mr. Thomas Mensah, a long-standing expert in maritime boundary dispute. In fact, he was the first president of the International Tribunal on the Law of the Sea. And he had also been an ambassador, I think, to South Africa at one point, but he was an expert in maritime law. And Ivory Coast also chose a judge ad hoc called Ronnie Abraham to represent them. And then you had the three judges led by the Algerian, and then one from South Korea, and then the other from Germany. So it was an overall impartial panel under the law which established the dispute mechanism.
Now, looking at the arguments that were presented at this tribunal when the case was being heard, the side of Cote d'Ivoire, the side of Ghana, what were the main points that we needed to look at in that particular one?
So, Ghana argued primarily that it had not violated Cote d'Ivoire's sovereignty and that there was a tacit agreement between Ghana and Cote d'Ivoire.
What does that mean? A tacit agreement? What does that mean?
It means that over time, through practice, through the activities of both countries, through the Ivory Coast's own laws and procedures and rules and regulations, that it had agreed to the boundary that existed, and during which area that Ghana really had been conducting its exploration activity. So I was arguing also on practice, that, under international law, you have a treaty law, which is the law itself, and then you also have customary practice, things that have been done over time. So over time, Ivory Coast has sort of adhered to that kind of arrangement that existed, even though it was not, there was no real bilateral agreement on paper that these are the boundaries. So Ghana's argued that that because Ivory Coast is almost like when somebody is building on your land, and you become aware of it, and you have allowed it to continue, it almost seems that you have agreed that it belongs to this individual. So the tacit agreement. The other strong point, though, raised by Ghana was that we should look at this issue from the delineation standpoint using the equidistance principle. The equidistance principle from the jurisprudence of the International Tribunal on the Law of the Sea and also International Court of Justice has shown that there is more predictable reliance in the use of the equidistance principle than the bisector principle. So Ivory Coast was arguing primarily on the bisector principle, and Ghana was arguing on the equidistance principle. The equidistance principle also has what we call, you take account of special circumstances. And really this goes to the heart of Article 15 of the United Nations Convention on the Law of the Sea. So how did the court take these arguments? The court rejected both the arguments of Ghana and Ivory Coast in the sense that Ghana was arguing that because there had been tacit agreement, therefore the tribunal, special chamber, should accept Ghana's position, which means that then there will be no need for the tribunal to delimit it, the boundary. The tribunal said no. There had been no tacit agreement. And so we asked the tribunal, will go ahead and delimit the maritime boundary. A lot of the argument was based also on, if you are delimiting the maritime boundary, you have to start from land and then get into the sea. And so there was boundary pillar 55. That was being used as the starting point. But the tribunal said no, you would use boundary 55 plus. And that also went in Ghana's favor. The tribunal eventually accepted Ghana's equidistance, the use of Ghana's equidistance principle rule, and then looked at special circumstances. So special circumstances could have included that, assuming that Ivory Coast was the one that had made these investments in the disputed area, then the tribunal would have looked at the special circumstances, for example, so the investments that Ivory Coast had made, and that any decision that it would make, it would have to take those into account and kind of arrive at an equitable settlement. Because Ivory Coast had not made any investment in that area, special circumstances could not be applied. The tribunal also reasoned that we didn't have a concave, we had almost like kind of a straight line, so you could use the equidistance principle to delimit the boundary. So by using BP 55 plus, Ghana actually not only saved its maritime boundary, but the cartographers are saying that Ghana actually also gained more.
Ultimate FM.
Now, both parties, Ghana and Côte d'Ivoire, signed and agreed that they are going to abide by the ruling which had been given by the tribunal. But was Ivory Coast really bound to accept it, or they could have decided that they were not going to accept the ruling and seek redress elsewhere?
So, I mean, yeah, so that's a very important question also, because as a matter of fact, under the United Nations Convention of the Law of the Sea, which again is the law which the tribunal applies, the tribunal, the decisions are binding on all parties. So this decision is binding on both Ghana and Ivory Coast. But the tribunal doesn't have powers of enforcement. So unlike so you take Ghana's own domestic regime. When you take a case to court and the court gives a decision, the decision is binding on the parties, right? Now, how does enforcement take place? In many cases, if it's a criminal case, especially, the state will use enforcement agencies like the police. So if a court rules that you have to be in prison, the police will take custody of you and send you to prison. Right? In this case, the tribunal does not have powers of enforcement. So that's one of the things that keeps on coming up in international decisions and international disputes. And in some cases, particularly in some of the cases that have gone before the International Court of Justice in Nicaragua versus U.S., the U.S. decided that it wasn't going to go according to its issue. So it's a real issue, but the Ivory Coast and Ghana, after the ruling, all said that they were going to go according to the decision of the special chamber. And by the way, when it gets, if assuming that Ivory Coast says that we are not going to be bound by it, there's no right of appeal. Unless, maybe Ivory Coast or Ghana goes back to the special tribunal and says, this order you made, I don't understand it. Can you interpret it for us? What does it mean? Okay. Same as what you have, let's say, at the Supreme Court.
Okay.
Supreme Court makes a decision. People can go and ask for interpretation and all of that. But pretty much at this moment, Ivory Coast has indicated that it is going to be bound by the decision, and Ghana will be making entities to make sure that there's cordiality going forward.
Very well. Thank you, Mr. William Nyarko. We are grateful for your insights and explanation this morning here on the show as regards this issue.